Here's why joint brokerage accounts are a mistake from an estate planning perspective. For one thing, there's no step up in basis. A joint account holder acquires the basis of the deceased joint tenant. There's no step up at death like other assets get. And so you're missing out on a capital gains savings of 15 to 20% of one half of the brokerage account's value by having it titled as a joint brokerage account. Secondly, the surviving spouse does not obtain creditor protections. If you were to send your half of the brokerage account through your living trust, the trust becomes irrevocable when you pass away, and the new trustee and the new beneficiary in most spousal situations would be your spouse, and so they get creditor protections because of the irrevocable nature of the trust. This can be a really big deal for Medicaid, especially. And in a Medicaid scenario, the government becomes your creditor. You have to repay the government for any healthcare expenses incurred during your lifetime at death in certain scenarios. And in a Medicaid scenario, the irrevocable trust asset for the spouse would protect the surviving spouse from having to do a Medicaid spend down on those assets. Thirdly, similarly, blended families. If you have a blended family and you don't send your asset through your trust, where you might have a qualified terminable interest for your surviving spouse, you're going to defeat your estate plan by having a joint brokerage account instead of having it titled one half and one half as joint tenants in common, which is the solution. Now, the last risk and the last reason that joint brokerage accounts are a bit of a mistake is that if the surviving spouse does not take the needed step to update the account after the first spouse passes away with a transfer on death designation or retitling it into the name of the trust, then that asset risks falling into probate. The entirety of the brokerage account, if individually held at death, will have to go through probate. In Virginia, that would just be if it exceeds $50,000 as a cumulative matter. Now, the solution is to furnish your certification of trust and trust documents to your financial advisor and to instruct them to title the account in the following manner: joint tenants in common, 50-50 for each trust. Not every broker can do this, but the good ones can, and you should try. If it doesn't work that way, if they won't do a joint tenant in common, then take 50% of the assets, put into an account held by one trust, and put the other 50% into another account held by your spouse's trust if you have a two-trust situation like we advise for married couples. So that's why joint brokerage accounts are a missed planning opportunity and potential mistake for clients. Thanks for watching. Reach out to us at Speedwell Law if you need any help with setting up a trust.